All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting. Please be seated.
Good morning and welcome to the Kansas Supreme Court. Before we call the morning docket, I would like to welcome those who are in the courtroom as well as those who are on our YouTube channel. For those who may not be familiar with the way in which the court works, I will explain that the court has received quite a bit of written material from the parties, the record of the case as it was in the district courts, as well as other materials, and had the opportunity to review those materials before today. So we are now welcoming the exchange that we will have with counsel as we ask questions about that we have developed based upon those readings. We also will be, as we do that, often looking at our computers, and just want to comment that and assure everyone that when we do that, we are still paying attention to the argument. We are trying just to find materials to help us assimilate the things counsel are saying with our understanding, as well as the questions that we are wanting to ask. With that, I would ask Mr. Doug Shima, Clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Thursday, September 14th, 2023 is appeal number 124726, State of Kansas versus Pedix McMillan, Sedgwick County, briefs both sides.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument. Chief Justice, if I could please request 3 minutes rebuttal.
3 minutes is granted.
Thank you, Your Honor.
May it please the court, Ryan Edinger, Assistant Appellate Defender, here on behalf of Pedix McMillan, present and ready for argument.
Second case is appeal number 123097, State of Kansas versus Cardell Turner, Sedgwick County, briefs both sides.
It please the court, Peter Meharry for Cardell Turner, present and ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Now ask counsel in 124726 State versus McMillan to please come forward.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. From a factual basis, this case is relatively straightforward as far as the crimes. The defendant was convicted of 3 counts of attempted first-degree murder for attempting to murder his wife, his then wife, and 2 children. But the procedural history of the case since trial has been anything but easy as far as getting the sentencing process completed. This is now the 3rd time that the case has been on appeal. His direct appeal challenging his convictions resulted in a remand to the district court for a speedy trial issue. After that was resolved, the defendant appealed again and raised for the first time a claim that his sentence was illegal. The Court of Appeals correctly agreed with that argument and remanded the case then for resentencing consistent with its opinion. At that resentencing hearing, the defendant again moved for a downward departure. And the district court concluded that it did not have jurisdiction to consider that issue at the time. The defendant appealed again, raising that issue, and the Court of Appeals also then sua sponte asked the parties to brief an additional question regarding whether the district court had the jurisdiction to modify the sentence on counts 2 and 3. So that's what brings us here today. Jumping into the first issue, which is my challenge to the panel's decision that the district court incorrectly determined that it did not have jurisdiction to consider a departure. And it's really a two-prong argument that I'm making here today. I think that the panel maybe lumped these together as if it was one argument, but there's really two separate things that I'm suggesting. First, I'm going to focus on the mandate rule. Our position is that this case, again, has been litigated multiple times at the appellate court level. In neither of the prior appeals did defendant ever argue that the district court had any way erred with respect to denying his request for a downward departure. So he made a strategic decision not to challenge that aspect of the district court's ruling. It was just on this now third appeal that he argued that it was then on the sentencing remand that he then again sought a departure. And our position is that the district court was correct in holding that it did not have jurisdiction. The mandate rule talks about when a remand order is stated in specific terms after deliberate litigation choices by the parties are not to raise new issues for the district court's consideration unless those issues arise from late breaking facts.
Let me be clear. Are you talking about, you're talking about the mandate rule, not jurisdiction, right?
Yes, this is my mandate rule argument, which is yes. And again, they are two separate things.
Okay, so when it goes down on, to correct count 1, isn't, this is hard for me to say, isn't a departure sentence inexplicably intertwined with sentencing under the Kansas Sentencing Guidelines Act?
I don't feel that it is, because certainly there are cases where neither party moves for a departure and even asks the district court to make findings of substantial and compelling factors. And so I think clearly there can be cases where if neither party seeks a departure, even at the original sentencing hearing, then the district court would not be called upon to make any findings that would support a departure motion. So I don't believe that necessarily in every case, the district court, even at the time of original sentencing, would have to make departure findings or determine whether a departure is warranted if the parties do not request that.
Your position that Judge O'Connor could not change the number on counts 2 and 3?
I don't think, well, and that, I guess that would obviously interact with the second issue here.
Well, here I'm thinking more in terms of that number was arrived at as part of a upward departure motion by the state. And so the question, I guess, would be, did he have jurisdiction to consider that state's upward departure motion?
I think in that situation that yes, and the distinction being that the state had from the outset in this case, that the ruling on the state's departure motion and the number that the court ultimately arrived at in granting the upward durational departure, that is in this factual setting linked directly with the ultimate sentence that the court gave in the first instance, because there was this confusion and ultimately incorrect calculation of how the court thought that it could get to, I believe the number was 1,068 months or something along those lines. And so I don't think in this case it would necessarily be possible to conduct the resentencing without having to consider the legality of whether the 330 months was appropriate.
So
But
if he can consider an upward departure, why doesn't it follow that he could also consider a downward departure?
Because it was not necessary to do so in this case in order to correct the illegality. And again, had the defendant ever argued previously, challenged the denial of the downward departure motion, then we'd be in a very different situation. And
Isn't
That
that what
gets-
the Court of Appeals opinion said, is that it wasn't necessary to touch 2 and 3 because there was no illegality?
well, and I disagree. I agree with what you said, but I disagree with the panel. And to be clear, you're speaking about the panel in this current 2023 appeal. But the 2021 panel that had remanded the case for resentencing in the first instance, they clearly referred to count. In that panel's opinion, they indicated that it was very clear that the district court had originally intended to designate either count 2 or count 3 as the primary count, because those were the only 2 counts on which the state had requested an upward departure and that the jury had made the findings supporting that. And so I know we're kind of blending issues 1 and 2 here, which is fine because it is obviously related. Our position with respect to issue 2 is that what could be a better indication of the ambiguity of this sentence as a whole than the fact that 2 separate Court of Appeals opinions reviewed the same sentencing transcript and came to different conclusions. The current panel in the 2023 appeal that we're here to review today said, no, when you look at the sentencing transcript as a whole, it appears that the court was designating count 1 as the primary count. But the 2021 panel said, no, when you look at the sentencing transcript as a whole and you consider the fact that counts 2 and count 3 were the only counts that the state had requested a departure on. And when you see the number that the court arrived at, it's clear that the court was trying to designate one of those 2 counts as the primary count. Our position on issue 2 is simply that when you look at the transcript, it is clear that there was, for lack of a better phrase, mass confusion. And I'll admit the prosecutor was confused as well. It wasn't just the court. But when you read that transcript, it's clear that they misunderstood exactly what the maximum sentence could be. They misunderstood how to get to that maximum sentence. It's also clear that the district court never once at that sentencing hearing expressly designated any count as the primary count of conviction. It also never expressly stated a length of sentence for either in any of the 3 counts. The prosecutor was basically saying, Judge, the way that we think you can get to what we consider the maximum potential sentence is to double the number on each of the 3 counts. And on one of those or 2 of those, you can impose these upward departures based on the jury's findings.
Doesn't the lack of a designation of the primary count alone make the entire sentence illegal?
That's exactly what we're arguing, Your Honor, is that this is something where, contrary to what the current panel held, we don't think it's a situation where you can say, no, the only count that was illegal was count 1, and therefore the only thing you can touch on remand would be the number of months that you can sentence him to on count 1.
I think the way the Court of Appeals cured that was to look at the journal entry.
They did.
And everybody signed off on the journal entry. And we have said that a journal entry can clarify an ambiguity at sentencing. So I think the question here is, was it an ambiguity? And as I looked at the second sentencing transcript, it seems that everybody in that hearing said, no, it wasn't a clarification. The journal entry was just a mistake. Is that a fair reading?
Yes, I think that, and I acknowledge the case law cited by the panel indicating that, yeah, if it's just something where maybe the court left something out at the sentencing hearing and didn't say something, but it's very clear from the context what the court was trying to do, then in that type of circumstance, it is in certain circumstances appropriate to look at the journal entry and say, okay, it's fairly clear from the sentencing transcript itself what the court was trying to do. Maybe it just forgot to say something or clarify something, but the journal entry in that situation, you can consider it in trying to figure out what exactly happened. But in this particular case, I think that when you read that sentencing transcript, it is so apparent that there was complete confusion as far as what the primary count was, what the maximum sentence could be on the individual counts, and then ultimately what the maximum controlling sentence could be. I think that this is a situation where you cannot just look to the journal entry to clarify it. I think that the original sentencing was just flat out illegal. It was a mistake, and the only proper way to remedy that is to remand it for a full resentencing on each of the 3 counts as far as which term of sentence is appropriate within the box. And then again, we do feel the court would have jurisdiction to consider an upward departure because the state had requested that at the time. I'm not suggesting.
Now, what about the downward departure? So how is that consistent with what you just said?
And I think that's, again, I'm not suggesting that there would not be situations where the district court would be able to consider a downward departure. But again, when you look at what happened in this case, the sentence, and by sentence, I'm referring to the term of months that the court imposed in this case. That sentence was arrived at based on the court granting the state's upward departure request. Obviously, we can never get to 534 months on any count had the state not requested and the district court not granted an upward durational departure. So in coming back for resentencing in this case, the court would necessarily then have to determine, again, what the appropriate term is based on its already existing finding that upward durational departure factors existed. But this court would not have to reconsider a downward durational departure in order to arrive at the sentence under these particular facts.
But it's not whether or not the district court would have to consider it. The question is, can the district court consider it?
Right.
And I just don't see why under the Kansas Sentencing Guidelines Act, when a district court is resentencing because of an illegal sentence, why it doesn't go hand in hand, that the district court can reconsider that and rule on it.
Well, 2 things. Again, first with the mandate rule, which talks about if the Court of Appeals order is stated in particular terms, parties should not be able to raise new issues. And here, I think the most obvious factual error that the panel committed is that in one point in rejecting our mandate rule argument, the panel wrote that this was not a case in which the previous 2021 panel had remanded the case with directions. Well, that's just flat wrong. I cited it in the brief. It absolutely did. The 2021 panel spent a paragraph talking about it. It's clear that what was trying.
The 2021 panel didn't even recognize that there was an error with the whole base sentence thing, did it?
That was why that was why the case was sent back, was because there was this determination that there was an error with respect to the sentence.
Why would the district court even have to have a hearing if it was if the mandate went down to just, here's what you need to do? Why would there even be a hearing?
Well, you have to have the defendant present for a sentencing hearing, even if it's just a formality. But in this case, there still would be, we would agree that the district court would maintain the discretion to determine within the box whether to impose low, middle, or high number. The defendant would be free to argue at the resentencing.
If the district court can consider that within the context of the Kansas Sentencing Guidelines Act, why can't the court consider, in conjunction with sentencing for that count, a request for departure?
Well, this court's case law has been clear that when a case is remanded for resentencing because of an illegality, the district court's jurisdiction is limited to essentially fixing the illegal portion or portions of the sentence.
Right. So
So-
count 1 was wrong, right? I mean, it was the whole thing with the base sentence. And this is not consistent with your argument that when it goes back down, because the whole thing, the entire sentence was illegal because of the primary crime issue.
The
So it's-
numbers were illegal. There has never been an allegation by the defendant that the court committed any error of any kind in denying his departure motion.
Well-
And that's where I cite in issue 1. We acknowledge that, yes, there are cases where this court has remanded cases and allowed for
The
reconsideration.
reconsideration. It was a motion to reconsider. You know, okay, now you're resentencing me. And I want you to reconsider my departure sentence. It's not like there was an error before.
And that's precisely the point. That's exactly my point. In the cases that the Court of Appeals panel in this particular 2023 opinion cited to say that there would be jurisdiction for the district court, they cited cases in which the error that had been committed in the first instance directly related to the denial of a departure or the granting of a departure. And so in those cases, for instance, I think all of them involve situations where the district court had either granted a departure, but had failed to state substantial and compelling reasons.
Counsel, can I jump in here
course.
and ask, are you familiar with the State v. Jamerson decision
Yes.
from this court? That seems to me to be at least one authority that is relevant here. Justice Johnson dissented in part, joined by Justice Breyer in that case. Are you what I'm trying to figure out is, are you arguing the position taken by the dissent in that case, which is that that a remand on a finding of an illegal sentence should not be characterized as a resentencing, but instead should be simply a correction limited to the illegality? Is that the position really that you're taking?
I think my argument is very closely aligned with that yes, and I think I argued in my petition that essentially Jamerson stands for the proposition that when a case does get remanded for a sentencing issue, the district court's task and its jurisdiction is essentially limited to correcting whatever
That's what the dissent in Jamerson is arguing, but it's a dissent. I mean, that's what I'm trying to figure out.
But I do think that
for you to prevail, it sounds like you're asking us to adopt Justice Johnson's dissent in Jamerson as the new majority rule.
I don't know that you would actually even have to get there, because I think that in general, the case law stands for the proposition that when a case goes back for a correction of a sentence, that the district court is only to fix whichever portion or portions of the sentence.
What Jamerson majority actually said is that the district court only has authority to resentence the illegal sentence. But if there are additional counts that were not found to be illegal, it doesn't have authority to touch those. But you've conceded that this entire sentence was illegal. So I'm just struggling to figure out how you're trying to.
Again, our argument is that the entire sentence is illegal with respect to the numbers within the grid box.
Right.
There's no allegation that the district court committed any error with respect to denying the defendant's departure motion.
Not to belabor the point, but are you willing to concede that that is the Jamerson dissent?
That is of course. And again, I don't think that has any direct relevance as far as addressing this issue of, okay, but if you can correct then the numbers that the court is setting for the 3 counts, does then that also mean that the court automatically has discretion to or authority to also consider a departure? And I think the biggest issue that I take with the panel's opinion with respect to this departure issue is that it ruled extremely broadly. What it found was that a district court can consider a departure whenever it is sentencing a defendant, including on remand for resentencing. I think that's far overbroad. If it's a situation, let's say that it's even more blatant in this case. Let's say the defendant has never, even at the time of original sentencing, requested a departure. And that the only issue is perhaps we have let's say an easy example to come up with. Let's say on direct appeal, the argument is, my sentence is illegal because of a Wettrich issue. And so we need to come back and figure out whether this prior conviction should have been scored as a person or a non-person. Obviously, that issue has nothing to do with whether a departure sentence should have been granted when the defendant has never requested one in the first place. So in that situation, if the case is sent back to correct or resentence, whichever phrase you want to use, to determine whether it should have been scored as a person or non-person offense, under this panel's holding, if it stays good law, the district court would then have the authority to consider a departure. And we think that is a grossly overbroad holding. And I don't think that it's consistent with the case law that the panel tried to rely on here. Again, they're citing cases where the error that the district court made in the first place had to do with the departure decision.
How far would you take that logic then? Because if we're parsing the sentence itself as to decisions made by the district court, the decision on the departure is one, but another decision is that the district court chose the high number in the box. And is that a decision that can be revisited? Because you said a little bit ago that it could be.
I think, yes, I think that in that situation, and I think that my logic there is simply that in determining the sentence, the court does, I guess, just by necessity, in determining an appropriate sentence within the grid box, you do always have to make that decision as a district court. You don't always have to consider something like a departure when it's not requested. So in setting the terms of month, the district court is necessarily looking at that sentencing grid, seeing the three options and making an assessment as far as which one of those would be appropriate.
But the basis for you saying that is because it's consistent with the Kansas Sentencing Guidelines Act, and also consistent with the Kansas Sentencing Guidelines Act is that a judge can consider a motion for downward departure. I don't really understand how you're distinguishing between those two.
Well, and I guess that's where my two-prong argument on issue one comes into play, would be that even if you don't agree with my overall jurisdictional argument on issue one, we have the mandate rule to look at. And when you look at the remand order from the panel in 2021, they spent a lot of time talking about how the court arrived at its total term of months. And then they said, but clearly that's incorrect. You can't get to 1068. The maximum number should have been 1029. In order to do that, it's clear that what the district court was trying to do was designate either count 2 or count 3 as the primary. And then it said, we remand we therefore vacate McMillan's sentence and remand with directions that the district court resentence McMillan consistent with this opinion.
What if the Court of Appeals was wrong and that wasn't the district court's intent?
Well, then we come back. I mean, again, that would be getting into issue two, which is that it just shows further that the term of month sentences on each of the 3 counts was ambiguous. And therefore, we do need to have the ability to resentence on the term of months for each of the 3 counts. But clearly, when they say that they're remanding
But doesn't that undermine your mandate argument?
No, I don't think it does. When they're saying that we're remanding for resentencing consistent with this opinion, what's clear, I think we can all agree on. Nothing in the 2021 opinion had anything to do with the defendant's request for departure. It wasn't raised.
But it doesn't matter.
If they're remanding the case for resentencing consistent with this opinion, and this opinion has nothing to do with a departure motion.
But the Kansas sentencing guidelines say when you're sentencing defendant, you can file a motion for downward departure.
But if you take that to the extreme, then the mandate rule is meaningless. The appellate court would never have an ability then to confine the district court to any one particular thing, because you would just have to always look at it as a complete carte blanche. You can do whatever you want as if it was an original sentencing hearing.
And that's what, and isn't that what the legislature wanted?
I Well, if that's what they wanted, then clearly this court has not followed that because it's very clearly held, as Your Honor pointed out, that when it's sent back for resentencing, it's limited to fixing whatever the illegal portions of the sentence is. So I don't think that there's been any
I don't, are you referencing our discussion about Jamerson?
yes, that when the case is
That
sent
holding
back,
wasn't the way you just described it with respect to only the illegal portion of the sentence. That was one where we had multiple sentences and the holding was you can only correct the sentence that was found to be illegal. But you can, it's essentially a resentencing of that.
but my point being, you can't, I guess I don't see the distinction between what I just
The
said.
distinction is that within a sentence, you can have legal elements of the sentence and illegal elements of the sentence.
Right, and Jamerson
And
is
you're
saying you can
arguing-
only fix the illegal portion.
That's what
No,
the Jamerson decision.
Jamerson had 3 counts. And all 3 of those counts were addressed. And the Jamerson appeal from this court said, you can't do anything with the 3rd count. That 3rd sentence was legal, but left it okay and wide open for the 2 sentences that had been illegal for the court to address those.
And that's what I'm arguing here. The departure in this case would be akin to the 3rd legal sentence in Jamerson.
As I read the briefs here and I've heard your arguments, I was reminded of, I think it might be Clapus 2, where there was a discussion about the difference between the mandate rule and law of the case. Where law of the case being settled if an appeal is taken and that's not an issue on appeal, and or is an issue on appeal decided. With that meager, I don't know if you remember that offhand, but with that meager description, does that sound like what you're talking about? Is that the departure motion is now the law of the case because it was decided and not appealed?
I don't remember that portion of Clapus offhand, but from your description of it, it certainly seems very similar to the argument that I'm making. I think it's always somewhat confusing with things like law of the case or res judicata or collateral estoppel. Sometimes it's confusing to keep them all straight. But I think that, I guess if there's an overarching theme to all of these things, and I guess maybe you could add the mandate rule into that as well, is that clearly there is a policy in favor of some degree of finality to litigation on appeal. And that, yes, when you have an issue that has never been challenged throughout these multiple previous appeals in the case, that it does seem like the prior appeals should have some merit, some consequence. And that if the defendant, for whatever reason in this case, has never challenged, and again, frankly, my concern is with how broad the district court's statement or the panel's case statement was in this case. I would hope that in this particular case, where this man tried to murder his 2 children and his wife, maybe I'm speaking out of turn here, but I would like to think that even if the district court had jurisdiction to consider a departure, downward departure, that he would be unlikely to grant it. But my concern is from a more global perspective here, that again, if this opinion is allowed to stand, and I realize that it's unpublished, but courts looking at this would then think that in any situation, even if it's never been asked to consider a departure in the first instance. Maybe we've got a case where the only reason that it's sent back to the district court is because there was a failure with respect to announcing the post-release term. So there we wouldn't even have an allegation that there's anything illegal with respect to the term of the prison sentence, let alone whether a departure should have been granted. And yet, under a literal reading of this panel's decision in this case, you would then have a situation where instead of just coming down to fix whatever happened with respect to post-release, you would then be able to relitigate a departure. And so our position again is that you need to look at the facts of the individual case. And in this particular situation, we feel that with respect to issue 1, The district court correctly determined that it did not have jurisdiction to consider a downward departure. And second of all, with respect to issue 2, that the term of months imposed on all 3 counts were illegal because of the confusion and ambiguity, and that therefore, upon resentencing, the court did have the authority to fix not just count 1, but counts 2 and 3 as well. And that included the ability to designate whichever count it saw fit as the primary account, and then arrive at a total sentence based on that determination. I fully acknowledge it's a very confusing set of circumstances with the procedural history in this case. And again, I acknowledge that the state at the original sentencing hearing was part of that. But clearly, regardless of what the state did or did not say, it's obvious that the district court was confused with respect to how to get to the final sentence. They imposed an illegal total number. They failed to ever impose individual sentence on any of the 3 counts, and it failed to ever designate which count it was intending to be the primary count. So in that circumstance, a full determination of the appropriate grid sentence or upward departure sentence was appropriate, but not a determination as to a downward departure.
Thank you.
Thank you.
May it please the court, counsel. Brian Enninger. I'm here on behalf of Felix McMillan, and I suppose I could start with just this idea of the first mandate. I know the state has argued that it was the district court was restricted by that mandate to impose the sentence that the state would like to see imposed. The issue with that is that that McMillan first panel, when they issued that mandate, it just said consistent with this opinion. I think that has to be read to mean the rule was he cannot be sentenced to anything more than 1,029 months. That's the nature of the mandate in this case. I don't think there's anything more to that. With regard to this question of really ambiguity in the court's original sentence, as I argued in the brief, I don't see where the ambiguity really is. What I see is a lot of haste. I see a big rush to give the defendant the maximum sentence he can possibly receive under the law. And I see the cap being treated as, a goal rather than a cap. And I would refer the court to volume 16, the sentencing, where the state says we are specifically requesting the high number and the appropriate sentencing guidelines grid box as to each count. That would be 267 months as to count 1. So that has to be the primary count because that's where the criminal history is being applied. So the state is the prosecutor specifically requests that as it goes. And I think that's really important. It lays it out right at the beginning. That's what we want, identifies that as count 1. The district court then imposes that exact same sentence that was requested by the state. Count 1 was illegal in that sentence because the court was applying aggravating factors that were not found by a jury to that count. So under Jameson, Warren, Gruber, all those cases, the only thing that could be corrected was the illegal portion of the sentence. Count 1 was the only legal portion of the sentence. So that is all that the district court has jurisdiction to correct on remand.
At the second sentencing, though, as I read the transcript, the defense counsel said, Judge, all of this is so intertwined, use the inextricably intertwined language. So where does that leave us? If the defense counsel at sentencing agrees, and I think there were comments made by back and forth during that hearing that the journal entry just did not reflect what was done in the courtroom or wasn't meant by the sentence.
I would say that the journal actually very much does reflect what was done in that courtroom. It identified count 1 as the primary count, same on the journal entry. The terms are all the same as what, I know the court didn't say, here's the specific sentence for each count, but that was prefaced by the state identifying the specific sentence for each count and then requesting that the court impose that. And the court said, okay, that's what I'm doing.
We're to supply the judges the lack of judge-made findings with what statements from the state.
From what the state requested as the sentence.
But is that our law? Doesn't our law require an oral pronouncement of sentence by the judge?
Well, there was an oral announcement of the sentence. The court said, I know the court announced the total term.
Well, the court said,
Um,
here's 169 months.
Right. What the court said, here's 1,068 months. And that was but before he got to that point, the state identified how they wanted him to get to that point. And they specifically did lay out each term, and that's how you get there. So I don't think there's a lot of ambiguity, and especially when you consider the journal entry reflects exactly what was said by the state and adopted by the court. And then it was signed off again by 2 more prosecutors a couple weeks later. So I just don't see how you reach any kind of conclusion that there's this big ambiguity about what happened in that initial sentencing. And the fact that defense counsel later at his remand seemed to be confused by it, I don't think has any real bearing on what this court can do. That's essentially, I don't really see a lot more here. I think this Court of Appeals opinion is consistent with Jamerson. It's consistent with Warren. It's consistent with Gruber. And I don't see any reason for it to be overturned. Court has additional questions for me, I would yield the remainder of my time. Thank you.
May it please the court. Your honors, I don't have a lot to add other than just to reiterate that I think the strongest argument that I can possibly make with respect to whether the sentence as a whole was ambiguous is just to rely on the fact that 2 Court of Appeals panels reviewed the exact same sentencing transcript and came to 2 opposite conclusions.
Our law doesn't talk about just ambiguous sentences. It talks about illegal sentences that are ambiguous as to time and manner. Is there any ambiguity as to time and manner?
I think there is, because we don't know how did the court arrive specifically at the 1068. And yes, the prosecutor said what the prosecutor said. I acknowledge that. But the fact that she was confused, I think just further highlights the overall level of confusion and ambiguity. We don't know specifically which term or which count the court actually did designate as count 1. I think the correct answer is that it actually didn't designate anything as the primary count. The journal entry just kind of assumed that count 1 was the primary count, but the court didn't actually make that finding. And we don't know exactly how the court got to its ultimate number. So I think there is confusion with respect to what's the primary count and what's the specific term for each of the 3 sentences. And so again, I think when you have 6 Court of Appeals judges looking at the same transcript and coming to different results, I think that and I do think that, to your honor's questions to opposing counsel with respect to what defense counsel stated at the remand hearing, I think that further plays into this. Just like the prosecutor's statement at the original sentencing isn't necessarily dispositive, I would agree that defense counsel's statements at the resentencing aren't dispositive, but I think that both of those things, in conjunction with the confusion displayed by the district court and then the opposite conclusions reached by 2 Court of Appeals panels, I think that just shows that everybody who has touched this case has been confused as to what exactly happened at the time of original sentencing or what should have happened legally. So I do think that all those things combined, the common theme is that, I generally try to stay away from cliches, but this is fitting. It's clear as mud. Nobody really knows exactly what happened, and therefore it was ambiguous and it was appropriate to reconsider the sentence on each of the 3 counts. I know I well exceeded my time on my initial comments, so I thank you for allowing me to do that. And we would request that this court remand yet again so that the district court can resentence on all 3 counts, but not reconsider the defendant's departure motion. Thank you, your honors.
Thank you to both counsel for your arguments in this case. We will take this appeal under advisement. I'll now call 123097, State of Kansas versus Cardell Turner.
May it please the court, Peter Meharry for Cardell Turner. If I could reserve 3 minutes of my time for rebuttal, Your Honor. In this case, my client was convicted of attempted first-degree murder and attempted second-degree murder, along with a conspiracy count. After those convictions, he appealed to the Court of Appeals. The Court of Appeals ultimately affirmed his convictions with one dissent. Judge Malone dissented. This court has taken this case on a petition for review. Issue that Judge Malone dissented on, and certainly I think the main issue in this appeal is the question of ineffective assistance of counsel, which is certainly intertwined with the question of whether or not the jury should have been instructed on self-defense. Court of Appeals was unanimous that self-defense should have been given to the jury. It was unanimous that trial counsel was deficient for failing to request that instruction, but the Court of Appeals split on whether or not that deficient performance was prejudicial. It's our position, and certainly what Judge Malone laid out, that the prejudice prong of IAC certainly was met here. Fact is, the defense at trial, given my client's testimony, given the other evidence at trial, the defense at trial was self-defense. As Judge Malone put it, that was his only chance of an acquittal, was through self-defense.
And he went on to describe what we decided, a majority of this court decided in Dinkle, that provided no legal avenue to argue self-defense because it wasn't instructed on, was basically, I think, Judge Malone's point.
Yeah, that's exactly right, Your Honor.
And there is a distinction between this situation and Dinkle, isn't there? In that, in Dinkle, there were like 20 counts of indecent liberties or rape in that case. I don't recall the specific charge. And she was acquitted on 18 of the 20. Not sure which counts were what in terms of the convictions. Here, the difference is, and we said perhaps a jury verdict could provide guidance in that situation. Here, doesn't the jury verdict of conspiracy provide us some guidance? It clearly, when the jury considered and unanimously decided that your client's guilty of conspiracy to commit attempted first-degree murder, that's a pretty good indication they rejected self-defense, isn't it?
I don't think it is, because
Why?
they were never given that option to even weigh self-defense. They were never told anything about self-defense. And what they were left with is basically a confession to premeditated murder. My client got on the stand and testified, yeah, I pulled my gun and shot. Tried to shoot. The gun did not work. But he testified, I only did that because the other individual pulled his gun first. That's enough for first-degree murder.
Conspiracy doesn't require, you don't get a self-defense to conspiracy. And in light of all the facts that were presented, pretty strong facts, including the phone call that was listened to by the FBI and those kinds of things. There was just evidence. But yes, I don't understand how the self-defense instruction would have helped you in the conspiracy charge.
Given that they were not given any instruction on self-defense, what the jury was left to consider, left to believe, was that if my client intentionally, with premeditation, attempted to shoot somebody, kill somebody, that's first-degree murder. And I think that bleeds over to the conspiracy charge. So the jury is left with this idea, okay, well, he was guilty of first-degree murder, so clearly, I think he's guilty of conspiracy to commit first-degree murder. So I think the problem isn't just something you can silo to the attempted murder and attempted second charge. I think it infects the whole trial, because his defense, through his testimony, was self-defense, and the jury was never given any instruction, never getting any guidance as to how to apply that.
The premeditation element counter that?
I don't think the premeditation counters that, Your Honor, given instructions on premeditation, all it has to be is to think about the matter beforehand. Premeditation, I know this court says it's not instantaneous, but it's pretty close under this court's case law. Virtually any intentional act can account for premeditation. And certainly he testified, I saw the gun. So I thought about it, quickly pulled my gun and shot. I think that goes towards premeditation under the case law. and
A
how they're
better
instructed.
question would be, doesn't the premeditation element in the conspiracy counter that? Because I could see if you were just dealing with the defendant, that there could be premeditation that was so close in time that self-defense could be a part of it. But here we have him conspiring with someone who had, with the intent to commit a murder. So that happened under the facts of this case before he arrived at the scene.
I think the problem you have is that the first-degree murder charge, attempted first-degree murder charge, bleeds over to the conspiracy charge. When you have that being, through my client's testimony alone, satisfied, I think that just bleeds over to the jury saying, well, he's guilty of attempted first-degree murder, so clearly he's guilty of conspiracy. Like I said, I don't think you can separate the two and just say, well, this is a different charge. They're all clearly interrelated here, and the failure to instruct on self-defense impacts all of them. We would also point out a couple things as far as what Strickland talks about as far as prejudice. It talks about, in addition to, is there a probability of a different verdict? It also talks about fairness in the proceedings. And here, and this is one of the things this court said in Dinkle, we just don't have fairness in the proceeding when the jury is not instructed on the defense presented. Essentially, it's a one-person debate. You only hear one side. You only get the state's theory. And it is vital, obviously, to the defense that the jury is properly instructed on the defense that they are presenting to the jury so that they can weigh that defense and determine whether or not it applies. And the prejudice here, I think you also have to remember, an instruction on self-defense not only instructs the jury what self-defense is, how it might apply, but it also puts the onus on the state to disprove self-defense. They have to disprove self-defense as an affirmative defense beyond a reasonable doubt. And without any instruction, that burden is never put on the state. And I would also, the prejudice continues on appeal. Is now on the instruction issue, I'm arguing clearly erroneous instead of harmless error. Again, that switches the burden from me having to convince you there would have been a different verdict to the state having to convince you that it didn't matter and it was not harmless. So
Can we go back? The Court of Appeals just kind of assumed, since they found, they did more than that, but basically jumped to that the failure to request self-defense in the ineffective assistance counsel claim was unreasonable. And is it that automatic just because he didn't request it and maybe it should have been warranted, and we may find that, may not. Does that make it unreasonable in terms of the ineffective assistance of counsel claim? I mean, isn't there a different
no, I think
difference there? And why he said, I just didn't think it was kind of the state was laying out this argument why it wasn't appropriate, and he didn't make much argument. And I think he testified to, I didn't think we were going to get it. And does that render it ineffective? Is that unreasonable?
that is unreasonable because
Tell me why.
that was the defense without that instruction. And he didn't even ask for it. It was the state that brought it up, and the state said, we don't think it's warranted because of initial aggressor. Number one, he needs to ask for the defense he's putting before the jury. I think that's law 101. The jury had no avenue to acquit my client, given his testimony. So he has to ask for it. And as far as the state's argument, initial aggressor just limits self-defense. It doesn't eliminate it.
Right. And I understand that.
I think it's unreasonable, given the way the trial played out, to just say, no, I'm not even going to ask, because that's the defense he presented, but he didn't ask for an instruction to match. So we believe that it certainly was prejudicial. We think if you look at the evidence, it is not as overwhelming as the Court of Appeals would like you to believe. Certainly, as was mentioned before, the gun did not go off. Gun didn't go off because it had the wrong ammo in it. My client, according to the state's theory, was a cartel hitman. That doesn't seem to coincide with somebody putting the wrong ammo in a gun. Certainly, his testimony that the supposed victim pulled a gun first, I think is backed up by the fact that the supposed victim, who the state says was unarmed, then chased my client after the fact. That doesn't seem like a bright move to me, that you chase an armed hitman. So I think the facts are not as clear cut as the state wants you to believe. And here it was vital then for this jury to be instructed on self-defense so they could apply that defense and see if that applies here to acquit my client.
On the Strickland prejudice prong, you'd mentioned that not only the likelihood of impact on the verdict, but also fundamental fairness of the proceeding itself. But hasn't the U.S. Supreme Court in our cases sort of limited that second consideration to situations where it's akin to a structural error?
Well, and I would argue, I think they kind of liken it to some extent to that. I understand that. But I think this is where the defense doesn't get his defense presented to a jury is virtually structural error here. It's in that line where it's just a fundamentally unfair proceeding. It basically says we're going to instruct a jury on the state's theory, period. Even though the defense has a defense, has presented testimony, presented evidence towards that defense, we're not going to instruct the jury. That seems fundamentally unfair. And that's, I think, adds to the prejudice here and shows that this proceeding needs to go back so that he can present his defense to the jury. If there are no other questions, we would ask that this court send this case back for a new trial so that he can present his defense to a jury. Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Your honors, I'd like to start with the first issue that I raised in the state's conditional cross petition, which is the question of whether a self-defense instruction was even factually warranted. And as I'm sure you've seen in the petition for review, I think that the starting point for that analysis should be the question of what standard do appellate courts judge that by, specifically in a situation like this, where the defense has not requested a self-defense instruction. And I cited 3 or 4 cases from this court that very strongly show that this court does seem to apply a different standard test in situations where it's not requested. And I cited, I believe Williams is the case that's about 10 or 12 years old, where this court acknowledged that its prior case law had been somewhat unclear because it would refer to clear error as a standard of review. And in Williams, this court essentially said, look, that's a misnomer because clear error is essentially a determination of whether something is harmless after you've already determined that there was error. And so in cases like McCullough, which I cited, I think that's my strongest case, because McCullough was a situation where the defendant at trial requested self-defense. On appeal, she argued that both self-defense and defense of others were warranted. And this court said, well, she requested self-defense. And so we look at the evidence in the light most favorable to the defense in determining whether that was factually warranted. But then in the very next paragraph, this court said, but we apply a different standard to her claim raised for the first time on appeal, the defense of others was also warranted. And so our position is that while there has certainly been confusion on this issue over the years, that case in particular shows that the failure to request an instruction should affect not only the reversibility harmlessness inquiry, but also the determination in the first instance of whether it was factually appropriate. We feel that when it's not requested, that the appropriate standard would be to review the evidence without deference to the defendant or the state. I'm not suggesting that it should be a light most favorable to the state standard. I think that it should simply be akin to like an immunity proceeding where the district court's role is to review all of the evidence without deference to either party and then make a determination of whether it feels that the evidence warrants dismissal. In this situation,
Is that consistent with what we decided recently in cases that even when we're applying a clear error standard, we still look at least the lack of the request of a jury instruction in the light most favorable to the defendant? I think we said that time and time again. And why should we change that?
well, I think you're right. Even since Williams,
Yeah.
it's continued. Basically, Williams said this is a mistake we've been making, referring to clear error as a standard review, but then subsequent cases seem to continue that. I think the reason you should change it is one, for clarity. I think this case gives an opportunity.
This is what we do.
But I think as far as, the other reason to change it would be that I think that a defendant's failure to request it should have an impact, much like we see this court. Obviously, this court
does have an impact. It kicks you to clearly erroneous. That's a significant impact.
It's an impact, but it doesn't affect whether this court finds that it was error in the first instance. And we see in the evidentiary context, this court is steadfast that a defendant or a party has to raise an evidentiary objection below, or else the issue is just flat out waived and abandoned. And that's in something as important as whether the evidence even should have come into trial in the first instance.
That's by statute.
I would argue that the statute here also indicates that the self-defense, the affirmative defense instructions that the statute talks about if it's supported by competent evidence. So I acknowledge that's not quite as clear cut as the contemporaneous objection rule. But I do think that in determining whether evidence would have been competent, that the failure to object should nonetheless weigh into the calculus of whether it was erroneous in the first instance. And I gave the example.
If there's no objection, though, we don't consider whether it was error at all.
Correct.
Don't consider it.
Which is my point. If this court is willing to completely deny a defendant the ability to even get a review of whether the evidence should have been admitted, which I would argue is even more important than whether an instruction was given, then it certainly seems like it would not be unfair to say, okay, in an instructional context, we're not going to completely bar you from raising the issue, but we are going to hold you to a higher standard in proving to us that it was error in the first instance. So we're not going to give you the benefit of saying, okay, even though you didn't request it, we are going to now scour the record in the light most favorable to you to determine if this was an error for the district court to not sua sponte issue an instruction.
What is the test on review for factually appropriate?
Whether there was, well, it depends, I guess, on the context. Like if it's a lesser, it's whether there would be some evidence that would reasonably justify a conviction.
Right, that would allow a reasonable juror to find, right?
Right, and that's in the context of lessers. Now,
isn't it also, I mean, is it different from the factual appropriateness prong of, let's say, a self-defense instruction?
Well, again, the statute there uses the phrase if it's supported by substantial or by competent evidence. That's in KSA 215108C. So the language is a little bit different.
So my follow-up question then, isn't that a legal determination? It sounds like you're asking this court to engage in factual finding, and I understand that's may make initial sense because we're talking about quote unquote factual appropriateness.
Right.
But isn't the determination of factual appropriateness a legal determination?
I think it's a hybrid determination. I think that you
How?
have to get,
If it's hybrid, then how aren't appellate courts are making fact findings?
I think, well, clearly they are having to look at the facts to determine whether it was, I mean, I guess.
And you just,
that-
you look at the record. And you
Right.
say, could a reasonable juror, hearing all this evidence,
But that requires.
and that's a legal determination, isn't it?
But it requires a review of the evidence, which is a factual. And I think this opinion by the panel, I think very clearly.
Well, let me just interrupt, sorry,
Sure.
one more time. It does require a review of the facts in the record. But that review simply asks, would a reasonable juror, could a reasonable juror have found that this defendant acted in self-defense? That's different from what you're asking us to do, which is to look at the record kind of as a neutral arbiter. You referenced immunity and come up with our own factual determination about which side, which weight greater. And that is a factual determination.
Well, I think that the reasonableness, I guess, that's where I would argue that it's especially important to determine what the standard is to judge that. Because, and I think this case illustrates how important the standard is. Because in determining that it was factually appropriate, the Court of Appeals numerous times in its opinion highlighted the fact that it was reviewing the evidence in the light most favorable to the defendant. And so I think that illustrates to me why this issue is so important. Yes, Your Honor.
I don't want to interrupt, but I do want you to address the thing that's always bothered me about you've made this argument before. But I'm also hearing something different. So let's start at the beginning. What's bothered me about the argument generically that, when an instruction wasn't given, we look at the evidence, whether it was factually appropriate in the light most favorable defendant. The reason from my perspective, I've always thought that made sense because the sua sponte duty on the trial court to make sure all the right instructions are given in a case. And so the standard for putting a jury instruction out would be in the light most favorable to the party requesting it. So, but the duty shifts up. There's no duty on objecting to evidence. Statute's clear. The duty's on the defendant. You don't object, you're done. But here there's a duty to the trial judge. Okay, so that's why I've generically have rejected your argument. But with this are you saying there's something different about self-defense that when we're looking at whether the court should have sua sponte instructed on self-defense, shouldn't look in the light of the defendant? Is there something unique about it? Does that make sense?
As opposed to like lesser instruction or other instructions?
Yeah.
It's an excellent question. And it's something that I thought of, my colleagues and I thought of as I was preparing for this argument. I don't know, when you compare the language of the supported by competent evidence for an affirmative defense compared to the some evidence that would reasonably justify for the lesser, I don't know exactly how the scales weigh in that, whether one of those would be considered a tougher standard or more lenient. To me, they use different terms, but I think that they are to some degree similar. You're still having to review the evidence. I think the word competent in some ways is analogous to whether the evidence would reasonably support a lesser. I think that one of the other concerns that I have with the panel's opinion in this case is, even if you set aside the question of, do you look at it in the light most favorable to the defense or some other standard, is I think that even if you're going, regardless of whose favor you're weighing the evidence in, you should at least look at all of the evidence. So specifically in this case, The only thing that the district court looked at in concluding that it would have been factually appropriate are very isolated pieces of the defendant's testimony, where he
Oh,
It
says,
wasn't, well, no, go ahead.
Oh,
Steve.
I'm
No, I
sorry.
was just, it wasn't isolated. The explanation that the defendant claimed that he was acting in self-defense was pretty clear.
but I think they minimize, if not ignore, in determining whether it was appropriate. I think the panel almost ignored the other portions of his testimony
And
where,
that was basically my dissent in Haygood, and it landed as a dissent. I mean, that's where it is. That isn't what this court has determined. It's whether it is, could allow a reasonable, a rational fact finder to reasonably conclude that the defense applies. And why isn't Turner's testimony meet that standard?
because again, I think when you look at all of his testimony, including his own admission that he purposefully tried to catch these guys in a low and compromised position. Now, I've never been a hitman for a cartel. I've never tried to collect a drug debt. I've never tried to kill anybody.
Yeah, but
But-
can't a hitman be acting in self-defense?
Well, but I think the question is, if you're not going there with an intent to kill him or do something physically to him, if you're just going there to collect money, one would think you could come up, and especially I think on the facts of this case, and I could be mistaken, I think there was even some testimony that he had previously, days before, that this victim had essentially acknowledged that, yeah, I owe you some money. I just need a little bit of time to get it to you. So if that's the case, one would think that you could just go up to this person, not in a sneak attack, trying to catch them in a low and compromised position, but you could just go up to them and say, okay, I gave you your 2 days. Where's this money that you owe me? Instead of strategically rolling up with a gun in your lap. And I know there was discussion by the panel about the fact that having a gun in your lap or having it otherwise displayed does not automatically make someone an initial aggressor. And I would agree, certainly, that the laws of this state, for good or bad, do allow people to carry weapons. But I think that when you look at all of the circumstances, when you see him admitting that he was trying to catch them in a low compromised position and that he has the gun ready to access on his lap, and I do think, again, the panel failed to look at all of the evidence. At one point, they said that there really was nothing that would allow a real clear indication of the positioning. And they essentially said, well, I think you could, in light most favorable to the defendant, you could say that the victims wouldn't have even seen the gun. Well, you did have testimony from the victims that they were very close to this vehicle. And I think when you talk about the window apparently being about halfway down, I would argue that if I'm standing right next to a vehicle on the driver's side window and the window is halfway down, I think that there's a very good chance that these, even according to the defendant's theory that he had the gun in his lap.
When you're finished, I'm sorry.
No, I was just going to say, I think that there was evidence to indicate that that would have been visible. And that's, again, something that the panel seemed to just flat out ignore. So just globally, again, our perspective is that I gave the hypothetical in the petition because I think it really drives home the point that if this court, what I consider the ill that comes with just saying light most favorable to the defendant, even if it's not requested, and you don't have to consider all the evidence, you can just look at basically evidence favorable to him. And I gave the example. Let's say you've got a guy that goes into a convenience store with a gun. The video shows that the clerk is standing behind the counter, minding his own business, doesn't even see the guy come in. The guy walks up to the counter and in cold blood blows him away within 5 seconds of walking into the convenience store. If the defendant took the stand and in one sentence of his testimony said, oh yeah, I shot him because it looked to me like he was going for a gun. I thought he was about ready to shoot me, so I shot in self-defense. Well, under the standard that we've seemed to apply in some of these cases, that would arguably be enough. even though you've got a cold-blooded killing on tape, and there's no reasonable way that any juror looking at that case would find that it was self-defense.
Then it wouldn't be objectively reasonable, that defense. It wouldn't be legally appropriate, right? I mean, hypothetical. So
Well, I would hope not, but so often this court in the lesser context has held otherwise.
Yeah,
It
but
seems-
light most reasonable to the defendant. I guess you're saying that light most reasonable to the defendant is a different standard from could a reasonable juror find? And can you help explain that? How is
Yeah,
that a different standard?
I think if you say light most favorable to the defendant, you would essentially, the way I interpret that, and I think the way the panel did in this case, it's basically saying, if we take the evidence that was in defendant's favor and we just essentially accept that as true. So in that,
If that is what the Court of Appeals did, and if this court were to disagree with it, I mean, I can see that. Is your argument that you need some clarification on what in the light most favorable to the defendant means?
that would be helpful. I mean, I certainly, my primary request would be, as I argued, to no longer use that standard when it's not objected to. You know, I was looking, and I'll acknowledge this is not my petition for review. I was just doing a quick search for the federal plain error standard yesterday, and they refer to it as plain error in this context. And they say that error is plain only if it is so clear or obvious that it could not be subject to any reasonable dispute. So again, that to me would seem to indicate that at least the federal courts do apply a stricter standard in determining whether it was error in the first place, not simply in whether it was reversible. And so that's primarily what I'm asking. But short of that, yes, Your Honor, I would appreciate if this court is not willing to go as far as I would prefer, it would be helpful to see more guidance on what exactly light most favorable means. Does that mean that the appellate court has to simply take any little piece of testimony that defendant would be in his favor and just accept that at face value in, you know, despite all of the other evidence showing that it wasn't that way, or even the defendant's own testimony conflicting with it? But I think that, yeah, I would argue in this case, even if you don't change the standard, I don't think that the defendant's somewhat, I would say, conflicting testimony, because again, he did acknowledge he was trying to catch these guys in a compromised position, that he already had the gun accessible when he rolled up on them. I think that that conflicts with his own claim of self-defense, and it certainly conflicts with the audio on the phone calls, with the victim's testimony. I would point out that in the kind of the final piece of evidence chronologically is we hear the defendant on the phone as he's driving away from the scene. And I would say that wouldn't it stand to reason if you were going to collect a drug debt with non-violent intentions and somebody actually pulled a gun on you, that when you're back on the phone with your co-conspirator who's giving you basically directions, that you would say, oh, by the way, these guys pulled out a gun on me. But instead, he's just complaining about the fact that, man, my gun didn't fire. So I think, again, even when you look at just the defendant's own words, whether it's on the tapes or his testimony, it is internally inconsistent with self-defense, and it's certainly inconsistent when you look at the weight of the evidence from the victims and other certain.
And you just gave a very persuasive closing argument. I mean, that's basically what you did. You taken a self-defense version and the state's version with corroborating facts and maybe made a very convincing argument why self-defense doesn't apply. But does that preclude instruction?
I think that if it's, I mean, for an instruction to be warranted, there is the factual component. And so I think that if the facts are strong enough to show, and I think it's telling that, and I guess just to briefly touch upon the ineffective assistance issue, I clearly disagree with Judge Malone's dissent on this as far as whether it was prejudicial. And essentially he argued, and what counsel has argued, is that, well, without a self-defense instruction, it essentially doesn't give the jury an avenue to find in the manner that the defendant would have wanted based on his theory. And I think a couple of things. First of all, there are cases, we've all seen them. Anybody who's practiced criminal law as an attorney or a judge knows there are cases where the defense simply does not have any good legal theory. And in those cases, a lot of times we see defense is essentially just relying on reasonable doubt, burden of proof, and maybe they're hoping for nullification. But that doesn't mean that they don't have any chance to be acquitted. But I think more to the point with respect to Judge Malone's dissent, he essentially is saying, well, this took away a viable defense from him, and therefore it's prejudicial. Well, that's not the test. The test is whether there was a reasonable probability. It's not whether his odds of acquittal would have improved fractionally if he had gotten this instruction. He has to clear the hurdle of showing that there's actually a reasonable probability that he would have received a different verdict had this instruction been given.
I have a concern about whether the roles of the various people are being conflated. The attorney, the jury, the district judge, and the appellate judge. The district court instructs the jurors that they must follow the law, correct?
Correct.
And that includes an instruction to consider all of the evidence presented during the course of the trial, correct?
Correct.
However, jurors are not instructed to act in either an objectively or subjectively reasonable manner, are they?
No, there's not an express instruction to that extent, to that effect, no.
Given the district judge's duty to instruct on the law, isn't it then the district judge's duty to consider any defenses that are legal and available to the party, to the defendant, if the judge assumes any of the evidence to be true, even if it is unlikely to be believed?
Yes, and I think in this case, there was the discussion, as counsel pointed out, at the instructions conference, it was actually the state who first mentioned self-defense. The defense didn't even bring it up. It was.
But isn't that why it is appropriate for an appellate court to look at that evidence presented at trial in a light most favorable to the defendant?
I would submit not. I guess I just can't get around the fact that in almost every other context on appeal, the decisions made by the parties below has an impact on the standard of review. Even in constitutional claims, the defendant, if they are raising it for the first time, the defendant has to meet an exception and argue why specifically it applies in a certain case in order to even get the issue reviewed. So again, I don't think that it is inappropriate in this context we're not saying that if you're not objecting to, or if you're not requesting it, that you just flat out don't get review of it. I absolutely am not going that far. I think it's a reasonable compromise to say that when you don't request an instruction, that then on appeal, you should have a higher burden to sustain in showing that it was appropriate in the first instance. Because otherwise, I feel like we're just turning the appeal into a mini trial. The district court, yes, we obviously have the transcript and we can all read the exact testimony and we can see what exhibits were admitted. But there's obviously something to being in the courtroom and seeing the evidence, hearing the testimony. I think it's very telling in this case, and obviously we can agree or disagree on whether Mr. Pittman should have requested a self-defense instruction. But I think it's very telling that a then very experienced attorney who is now a judge with a lot of years under his belt as a criminal defense attorney testified at the post-trial hearing that, yes, I considered it. I did think about self-defense. It's not like this theory never crossed my mind, that instruction, but he ultimately concluded based on his professional opinion and knowledge of the evidence that the evidence did not get to that level. And I guess to cut off a question or to address a question that would be, well, why not ask for it? What's the harm in asking for it? And I would say that as an officer of the court, Mr. Pittman has a duty to not make requests that he feels are not supported by the evidence. It's a duty of, I don't know whether you'd say that falls under a duty of candor or just a general professional responsibility to not make frivolous requests. But just like as appellate counsel, we are not it's not effective advocacy to make arguments that you believed to be without merit. If his assessment of the evidence was that it didn't warrant it, and he thought to himself, you know what, if I request this, I'm probably going to have to then explain to the court why I feel it's factually warranted. And if he didn't think that he could make a good faith argument with respect to that, then I think it was appropriate for him to not request it.
So I'm assuming you're taking the position that it was not objectively unreasonable.
Right,
That's
yes,
kind of-
and we did include that in,
So
yes.
you're taking the, yeah, okay.
Yes, and we did include that in the cross petition, Your Honor.
Or other questions?
Thank you again for allowing me to go well past my 15 minutes.
May it please the court, I just have a couple things I wanted to point out. And as far as the standard in determining whether or not an affirmative defense should be given and how this court should look at the evidence, and frankly, how district court should look at the evidence, I think it has to be in the light most favorable to the defendant. Because otherwise, I think you get into the problems this court has identified where you're just weighing the evidence.
Do you read Haygood to say light most favorable to the defendant means don't look at the total record, only look at the evidence that the defendant produced in isolation?
I think you still look at the total record, but you look to see if there's evidence in the record in total that would support the defense.
That
Now,
would
generally,
permit a reasonable fact finder to find self-defense.
correct. And generally, that's certainly going to probably come from the defendant. But if there are.
The difference is that a defendant can offer testimony that just simply, if that's the only thing we look at and that's competent evidence, well, then it's factually appropriate. And that's different from the defendant testifies and then the court is supposed to, yes, still in light most favorable to the defendant, but look at the entire record and ask, would a reasonable fact finder conclude? Do you see the distinction I'm making?
I think I see the distinction, but I think the ultimate question is there evidence that the jury could rely on to support that defense? And that may just come from the defendant. It may come from some other thing. But I think you have to say, is there something the jury?
So you are saying then that light most favorable to the defendant means only look at the evidence that supports instruction.
I don't think you look at only the evidence that supports instruction. I think you look to see if there is evidence in the record to support the instruction. And
if there is, that's the end of
I think it is, because otherwise, like in this case, if you're going to say self-defense was not warranted, you're saying my client's testimony was not competent. And I don't think this court can say that. If the jury believes my client, it's self-defense. And that's a question of fact for the jury. And that's why the state's hypothetical about a video, that's simply weighing evidence. One is video, one is testimony. And we all may think, well, it's got to be the video, right? Maybe, but the jury doesn't have to believe that. A district court can't direct a verdict for the state on that type of situation because it's a question of fact. And that's why you have to look at it in that manner. Those are questions for the jury. That's why we have them there. In this case, they should have been able to make that call. Thank you.
Thank you to both counsel. We will take this matter under advisement. The court will now be in recess until 10:45.
Rise.